Jose, Ms. Lofgren.
Thanks very much, Mr. Chairman. Standard essential patents, those are SEPs, Mr. Chairman, for the acronyms, for many products comply with industry standards, and as you know, owners of SEPs agree to license these patents on fair, reasonable, and non-discriminatory terms. That's FRAND, Mr. Chairman, the acronym, to ensure that the technology is accessible. At the same time, the ITC can issue exclusion orders to stop the import of products that infringe on patents. However, these orders can be disruptive, especially when it comes to SEPs, because they could block the import of widely used products impacting businesses and consumers. I'm wondering if each one of you have an opinion on these two questions. First, the issue of monetary remedies versus exclusion orders. Considering the potential disruption of exclusion orders, do you believe that monetary remedies should be the first option, with exclusion orders reserved only for the most severe cases when SEPs in FRAND is involved? And secondly, given that commitment to license on fair terms, should the ITC avoid issuing exclusion orders when they conflict with FRAND commitments? How should we handle these situations to balance the needs of patent holders and their rights with those of the broader market? Anybody have an opinion on those two questions?
Thank you for the question, Congresswoman. With regards to monetary remedies versus exclusion orders, our position is that if there is actual infringement, that the first option should be those monetary damages and potential royalties, particularly as it relates to standard essential patents. They are licensed largely with the intent to monetize the IP, the intellectual property, and therefore we don't think that an exclusion order is appropriate. With regards to fair, reasonable, and non-discriminatory terms, we don't think that the ITC should be granting exclusion orders. We think that injunctive relief is not appropriate in that context because of the FRAND commitment that the SEP patent holders have made to license to all willing implementers.
Yes.
Yes, thank you for the question. As you know, undoubtedly, in 2013, U.S. Trade Representative Froman, representing the administration, issued the last disapproval of an ITC exclusion order that had been issued to Samsung against Apple, precisely because it involved standards essential patents. And Trade Representative Froman was very clear in his explanation of the disapproval that standards essential patents and standardized products are important for the U.S. economy, for U.S. producers, and to block the importation of products on the basis of standards essential patent was a very significant matter, and that the ITC had not adequately developed the record in terms of FRAND and standards essential patents in that particular case. And to its credit, the ITC has modified its procedures in the intervening 11 years so that there is a much more detailed record developed around SEPs, and the ITC has not issued any exclusion order against a product by virtue of infringing standards essential patents. And I think that's absolutely the right approach to take. When a company is involved in the standardization process, it makes a commitment of binding contractual commitment to the standards body that it will grant licenses of its patents on fair, reasonable, non-discriminatory terms. That means it agrees that if others are going to use its patents, it will accept a monetary royalty. And as long as a company is willing to pay that reasonable royalty, there's really no cause for an exclusion order or an injunction in court either. And so the only question is how much money that reasonable royalty ought to be, and that's a question that the courts will decide. So, I think that absolutely the ITC should stay away from exclusion orders in the FRAND context.
As Professor Contreras pointed out, the Commission has developed a procedure to develop record on SEP and to determine whether an exclusion order might be necessary. I think that the availability of an exclusion order, the threat of an exclusion order, needs to stay in place even for a potential SEP, to avoid the problem of holdout, of companies that say, well, yeah, you haven't offered me good enough FRAND terms, so I'm not going to license, and I'm going to keep going infringing because you can't make me stop. And ultimately, I think that the threat of the exclusion order is beneficial in that ultimately it might force the end of patent holdout in the case of an SEP.
I see my time is just about up, Mr. Chairman, so I yield back. Thank you all for your testimony today.
I'll thank the ladies so much. I now ask unanimous